So good morning, everybody. Christine, thanks again for the introduction. The goal today is to have you walk away with some more knowledge about the legal landscape when it comes to disputes inside nonprofit organizations, but more importantly, to walk away with some practical tools in your toolkit to deal with disputes or even issues before they become disputes, to minimize drama, time, and expense away from running your organization to the best of its ability. Disputes sort of get in the way of being able to run successful organizations, and so to the extent that we can minimize them or prevent them, then the organization is on better footing. So as we always do as lawyers, I'm going to just give you sort of an outline of what I'll discuss this morning. Basically, I'm hoping to keep the presentation portion to about 40 or 45 minutes so that there's lots of time for any Q&A. But if you do have any questions, as Christine noted, please feel free to post them in the chat or to take yourself off mute and interrupt me. And I'm happy to answer them to the extent I can. The agenda today is basically just to introduce myself, give you a bit of my legal background, and then to give you a little bit of terminology or lexology on some of the concepts that I'll be talking about throughout the presentation, just so that we're all on the same page. I'll go on to talk about dispute resolution and the intersection between resolving disputes and the law, and then talk about the, I guess, different tools inside a toolbox in terms of resolving disputes, namely negotiation, mediation, arbitration, and worst case scenario litigation. And then I'll focus in more on, and this is where the practical portion of the presentation comes in, but focus on the strategies, particularly for negotiations, so that you could avoid, to the extent possible, any kind of more formal mediation, arbitration, or litigation process, and some of the strategies that could be employed basically almost free of charge by not-for-profit organizations before things get too far along. And then, as I said, I'll leave some time for Q&A. So this is the slide I was going to say. Lawyers are always putting these in at the beginning of their presentations to say nothing that I'm going to say or show you is or should be construed in any way to be legal advice, and that the views that I'm going to express are my own and not necessarily that of my employer, Stewart McKelvey. And that if you do find yourself in a situation where you're not sure what your legal rights or recourse would be for your organization, that pick up the phone and call the organization's lawyer or give us a call, and we can discuss what kind of legal advice you might need in a particular circumstance. So just a bit about me. I'm a lawyer here in Charlottetown at Stewart McKelvey. I practice almost exclusively in the areas of corporate and commercial law, including governance matters for not-for-profit corporations, as well as charitable applications. I was originally called to the bar in Ontario, where I practiced for about 5 years before moving to PEI in 2022. My wife is from here, so we moved back here, and I've been practicing here ever since. I have lots of experience with not-for-profits, particularly in the health field and hospitals, but also with various associations, including sports associations. And I have seen firsthand sort of where disputes can arise, especially in the not-for-profit sector. And I see we have There's just a question from Yanni. So, which disclaimers and/or notices save companies a lot of disputes or cover them in disputes? What commonly overlooked disclaimers or notices could be helpful in protecting the company in the event of disputes? Yanni, I think to your question, anytime an organization is holding itself out publicly. So a prime example is your website. A lot of organizations, it just depends what kind of activities you're running, but some organizations on their website, for example, would have terms of use or a disclaimer right on the website to say that, you know, any of the information they're providing or any of the tools or resources that they're making available publicly by that organization, you know, like I've just said, you know, shouldn't be totally relied on, and that people should use common sense and get advice where they need to for their unique situations. Though those are always, well, not always, but they are generally very useful. It's useful evidence if anyone were to ever sort of raise an issue or cause a dispute or try to litigate against an organization to say, well, you gave me this information, and notwithstanding it was free and available on your website, I relied on it and I've now suffered damages. If you as a defendant can point to a disclaimer to say, look, we tell everyone who goes to our website, you can't rely on this information because we don't know what your particular situation is, and you should go seek professional advice if you need it, is good defense to deal with that dispute issue or litigation rather quickly. So I hope that answers your question, but happy to answer any follow-up questions you have on that. In terms of terminology, so I'm going to refer to these things throughout this presentation. When I speak of bylaws, I'm talking about the rules and regulations that are typically codified on incorporation of a not-for-profit organization that's incorporated to regulate the activities or affairs of that corporation, and they are approved by the members and typically instituted right from the get-go day one. A lot of my presentation is going to focus on not-for-profit organizations that are incorporated, so they're a separate legal corporation at law. Many not-for-profit organizations, I acknowledge, are associations of individuals or partnerships or another legal construct, but for the vast majority of a lot of not-for-profits, they are incorporated, typically either under the Companies Act in Prince Edward Island or the Canada Not-for-Profit Corporations Act, if incorporated federally. So that's sort of where a lot of the focus is going to be today on corporate not-for-profits. But a lot of the concepts would be applicable to any not-for-profit, even if they are not incorporated. Moving on, when I speak of policies, I'm referring to rules and regulations that are not contrary to your bylaws or your letters patent or articles, the constitutional documents that created the corporation in the first place, but they are rules and regulations that are instituted by the board of directors to regulate the affairs of the organization. They're not quite as binding because they're not necessarily member approved. They're rather approved at the director level. And I'll speak in a second about sort of how the organization, or most not-for-profit organizations, are organized and who gets to do what. When I say a corporation, I'm talking about body corporate incorporated under the Canada Not-for-Profit Act. So that's the Federal Not-for-Profit Corporations Act. And when I refer to company, I mean company incorporated under the Provincial Companies Act. Under our Constitution, we have federal and provincial powers that are enumerated, and the drafters of the Constitution allowed both the federal and provincial governments to regulate corporations. So both levels of government have their own statute, and depending on which one you're incorporated under, there are different rules and regulations that apply to your incorporated organization. A bit confusing, but it does matter if push ever came to shove in a legal dispute. So dispute resolution and the law. practically speaking, most issues and disputes, whether they are internal or whether they are, so your board is having a dispute amongst each other, or your members are having a dispute with your board, that's an internal dispute. External disputes could be a third party who's not a member, not a director, has a dispute or an issue with your organization, slip and fall, or they their membership has been revoked and they feel they've been treated unfairly, and what have you. So that's sort of more of an external dispute. There's practical ways to deal with a lot of disputes. And then in the background of any type of practical discussion or practical resolution that the parties are trying to resolve themselves, there's the law. And the law steps in where people themselves can't come to an agreement on resolving a dispute. And depending again on which act that your organization is governed by, and depending on, the party's preferences, there's different legal avenues you could take to resolve a dispute. So the law in the land is made up of a whole bunch of things. There's statutes. So those are acts that are passed by the provincial government or federal government. There are regulations that change from time to time that are appended to those acts. There are your organization's original letters patent or articles, or AKA the Constitution, that first birthed the corporation. There's your bylaws that would typically have been passed at the time of incorporating. There's board policies. And all of these things may include, depending on which organization we're talking about, may include specific instructions on how any kind of dispute or certain disputes are going to be dealt with if they arise. So I always tell people, we can try to resolve a dispute and see if parties can agree. But in the meantime, go and take a look at which act governs and what your options are and what your legal rights and remedies are under statute, your articles, your bylaws. Did they speak of what needs to happen? And do they speak of what needs to happen within a certain time period if a dispute arises? So it's important to know that the law is in the background, and there are certain things that maybe have to be done before parties can even engage in a dispute resolution process. There may be a requirement to engage in a certain process by a certain time. So the law is there in the background. Bylaws and directive policies allow for a corporation to mandate in advance of disputes how disputes are going to be resolved. So it's important when you're drafting these things, and I do it on almost a daily basis, is to think about, okay, in this organization, given its activities and its the number of board members and the number of members, what kind of disputes could arise, and how do we draft bylaws or letters patent in a way that's going to allow the organization to resolve disputes as they arise without having to go to the courts or spend a lot of money on arbitration or mediation. Like, what's the best dispute resolution process for an organization given its activities and its background and its members and directors? The wording's important, and it's always critical to make sure that those bylaws, they're not just frozen in time. So you're looking at them, you're making sure your directors, as they come on, are looking at them when they first come on the board of your organization. But B, that you're picking up those bylaws every, say, 3 to 5 years to make sure that they're still consistent with the best interest of the corporation and how it's currently conducting itself, and whether or not there's been changes to the law or changes to the organization that would mandate updating those bylaws to ensure that they're going to work when the time comes. I'm not a litigator, so I'll give you that caveat, and I only know enough about litigation to be dangerous. But in an effort to avoid the court process, which in this country, courts are really designed, and it's one of these systems that is intended to be designed to keep people out of it. It's a long process. It's expensive, but it's a very low barrier to entry. You can walk down to the courthouse, file an application or a statement of claim relatively easily and at very low cost, which allows you into this system. And it's designed that way to be fair, to allow people access. But once you're in that system, a judge is going to try to convince the parties at every step along the way before a trial or a hearing or a motion to resolve the disputes themselves without recourse to what are very limited court time and resources. So the system is designed to try to keep people out, and it's also built into it a requirement that basically loser could pay the cost of both their own legal costs and the other side's legal costs. So it's very important to and lawyers take a lot of time and energy to draft bylaws to ensure that you don't get all the way to a court process, that there's something before that process is initiated to deal with your disputes so nobody ends up there. It's sort of the option of last resort in my world. In terms of what is the highest sort of level of law of legally binding laws in the land, really you can't, if an act or a regulation is passed by Parliament or the provincial legislature that says the organization shall do X, Y, or Z, people can't agree to contract out of it if it's a legal requirement. So acts and regulations are sort of the paramount legal document, and you can't have articles or bylaws that contradict or conflict with what you're required to do at law. Then there's judge-made law, which interprets some of those acts and regulations, but may also put some padding around where there's gaps in the regulations, where the legislature hasn't told a corporation to do X, Y, and Z, where judges feel they should do X, Y, and Z. There's the common law. So that's judge-made law. And that's developed over hundreds of years. And there are common law principles that are binding on corporations and their directors and members, but aren't necessarily codified in the act or regulation. Then there's the letters patent or articles, which is basically the constitution that births your organization as a corporation. There is such a thing as a unanimous member agreement, and that's where all the members agree to certain things, again, not contradictory to law or to articles. Those are very rare, but they do exist. Next is your bylaws. So these are member approved rules and regulations for your organization. They can be updated year to year or from time to time, but they're ultimately approved by the members of the organization. And then there's board policies. A CEO or officer is going to have policies. And then lastly, there's agreement of parties to a dispute. And those are when all parties to a dispute mutually agree. They're not necessarily required to agree, but they all agree, well, notwithstanding the bylaws say this, everybody's happy if we just do that. So in the order of priority, this is sort of where the law creates a waterfall of what's binding and what's not binding. Again, which laws are lying in the background of your organization really depends on which act you were incorporated under, as well as your bylaws and policies that are in place. So Companies Act is a provincial PEI act. Canada Not-for-Profit Corporations Act is a federally regulated organization. And there's very easy ways for lawyers like me to search your organization and find out which one you're under. Corporate Law 101, and I always try to give people a metaphor or an analogy when I'm explaining things that are very complicated from a legal perspective, but from a high level, a corporation is basically modeled after a lot like our democracy. So like we have as voting citizens, we have the ability to vote who we want to run for and operate our parliament. Same as members have the ability to vote and decide who's going to be the board of directors for an organization. I don't have to, as a voting citizen, I don't have any obligations to the organization. I don't have any rights other than the ability to vote for the organization. I don't get any money from being a member of the corporation. I just basically have this right to decide who's driving the bus in terms of regulating its affairs. A board of directors, like Parliament, those are the folks who are going to be the mind and management overseeing the organization. They have obligations. They have obligations to ensure that the organization is operated in accordance with its bylaws and letters patent in the law. They have an obligation to ensure that any HST or payroll deductions or income taxes, to the extent payable, are all remitted to the Receiver General. They have an obligation to act in the best interests of the organizations that they serve. So they have a lot more of an elevated obligation to the organization. It's not just their rights as boards of directors, but they have an obligation to the organization to act in its best interest, the same way our MPs do. They have an obligation to act in the best interest of the members, failing which we'll vote them out. CEOs or an ED or any other officers are appointed by the board. Okay, so depending on what your bylaws say, the default is the board gets to appoint those folks, and they operate the day-to-day. They ensure that people are hired and they're doing their jobs, and whatever activities the organization is undertaking are carried on. So this is sort of a hierarchy to keep in the back of your mind when we're talking about an incorporated not-for-profit corporation.
Andrew, I see Yanni has a comment there. Is that what you're addressing?
Perfect. So this seems like a hierarchy of laws, i.e. Constitution, Companies Act, bylaws, policies, or which statutory articles and rules fit in the hierarchy. So Yanni, I think you're talking about this waterfall. So statutes and acts are the same thing. Regulations are sort of rules that are appended to those acts or statutes. Articles are here. A lot of articles can be quite simple. Set out simply the name of the organization, how many directors or a range of directors that it has, but more importantly, its purposes. So what it's actually going to be doing and what activities it's going to be undertaking. But a lot of articles can be fairly basic, and other than those three things, not contain a lot about when meetings need to be held, how meetings are going to be held, how disputes are going to be governed. It would be very rare to have more of the minute or detailed processes about how the affairs are going to be run in the articles. Those are typically reserved for the bylaws. And the reason for that, quite frankly, is practically speaking, bylaws can be more easily changed and approved by the members without having to go back to the government and refile and get articles of amendment or supplementary letters patent, as they're called under the provincial statute. So, and there's a cost and a fee associated every time you go back and amend your articles. So typically, the more routine or the affairs and management of the organization are typically reserved for the bylaws or board policy. Contracts and agreements, I agree, would be here. But again, contracts can be voided for illegality. So to the extent that the parties contract to do something that's illegal, a court would refuse to enforce that. And articles we talked about, so they're sort of in the middle of the hierarchy. Hope that answers your question, Yanni. Just a brief synopsis of bylaws. Bylaws are required, but what's required to be in them, there's a lot of options and a lot of flavoring that can go into bylaws. under the provincial statute bylaws, there's section 90 sub 2 outlines what should be included in them, and those are mandatory, but there's a lot of optional clauses you could have as well. Under the Canada Not-for-Profit Corporations Act, if your organization is governed by that, there's actually a bylaw builder tool that Corporations Canada has developed, and it's fairly nifty. It's available online. You can basically go in and select optional clauses and revise mandatory clauses as you see fit, and it'll spit out a PDF or a Word document of those bylaws that are basically government approved for use by an organization governed under the Canada Not-for-Profit Corporations Act. So if you search bylaw builder Canada Not-for-Profit Corporations Act, you'll find that website. Policies, boards are allowed to make policies that are not contrary to your articles, bylaws, etc., which would deal with any disputes or how to address disputes. Things like employee policies or Robert's Rules of Order for how to conduct board meetings are the types of policies that I'm really referring to here, and those things will be permitted typically under articles or the law in order for people to avail themselves of those mechanisms.
Excuse me,
And
Aaron has a question in the chat.
oh yeah, Aaron. Can someone remind me, if you're not incorporated under Corporations Canada, what is the other governing body? Prince Edward Island Corporation. I may have missed it. Yeah, so Aaron, it's the Companies Act of Prince Edward Island. And if you search for PEI Business Registry, actually PEI Original Business Registry, you can search for Part 2 not-for-profit companies that are incorporated under that provincial statute. And that'll show you if it comes up that you are incorporated under PEI law. There's the same if you Google federal corporation lookup and search for your corporation. If it's under federal law, it'll come up in that search. So both provinces have an ability. It's called Business Registry and PEI, and corporation search federally, but both do the same thing.
Vicky has put a link in the chat. Bylaw builder.
Yeah, exactly. So that's only for federally incorporated not-for-profit corporations. I wouldn't recommend using it if you're a PEI corporation. But thank you, Vicky, for finding that link.
Brenda has a question.
How different are the PEI standard bylaws to the Canadian Not-for-Profit Act? So they would address a lot of the same common matters like board meetings, members meetings, member qualifications. So who's allowed to be a member? Same thing for directors. Who's allowed to be a director? There's a lot of commonalities, but all the section references would be different. And the CNCA, the federal act, is a lot more modernized and detailed. So the PEI Act is a little bit older and more archaic and a lot more vague on what's required to be in bylaws. So as far as I know, and maybe somebody knows better than I do, but I do not think that there is a standard set of bylaws that are published by the PEI government for use in PEI for PEI corporations. Unlike the CNCA, where there is that infrastructure there that Corporations Canada has developed. So typically, like, our firm has our own standard form of bylaws that we start with for a PEI not-for-profit corporation. But I can guarantee you that every organization is going to have changes that they would want to see to any kind of standard. It's no one size fits all. Every organization is different. And so you really have to use any standard bylaw with a grain of salt and really review everything and make sure it's going to work for your organization, because it's not one size fit all, and you wouldn't want the bylaws to be like a square peg through a round hole. Like they won't work if they don't meet the organization's needs. In terms of main avenues for dispute resolution, as I said, we have the four main ones. So negotiation, so only the parties involved to the dispute, whether it's internal to the organization or some external party that has a dispute with the organization, the parties agree and meet and resolve the dispute on their own without any kind of third party intervening or overseeing the dispute resolution. Mediation is where the parties agree or are required under your bylaws to hire a neutral third party to work together to come to a solution. But at the end of the day, that neutral third party is not there to dictate how the resolution is resolved. They're simply there to see if the parties can come to a negotiated settlement by assisting the parties with communicating their needs and wants in the negotiations, see if they can come together, but it's non-binding. Arbitration is when a third party is there, and again, at the end of the day, they're going to hear from both parties and then come up with a binding resolution that's binding on both parties, and it's very difficult to override an arbitrator's decision. So they're a bit like a judge, but they're basically privately contracted to come in and arbitrate the matters. There, you will hear of things like mediation arbitration, which is a combination of those things, where the third party can try to help resolve the dispute, but then if the parties can't resolve it, we'll arbitrate it, so that, you know, the mediation process isn't a total failure, that at the end of the day there is a resolution, whether the parties like it or not. But really, we see normally those two processes are an either or and not an and. I see Brenda has another question. How would PEI regulate a not-profit bylaws if they do not have something to refer to for guidance in making certain their own bylaws align with the law and act? The answer is you'd hire a lawyer typically to ensure that the bylaws that the organization has do align with the act and law. So again, I may be mistaken, and the government PEI has posted a bylaw you could start from, but as you tailor it or make changes to it, somebody could be tailoring it in a way that is actually contrary to law. And the only way you can really have any assurance that your bylaws, either as you amend them or somebody else has amended them, are compliant with law, is to go and seek the advice of a lawyer. So negotiation, basically, I'll talk about the advantages and drawbacks of each sort of dispute resolution process, but the advantages of negotiation are the parties are able to work out their own solutions on their own, and that typically allows the parties to be more happy with maybe what a judge might impose on them. You're more likely to honor the results of those negotiations because each party had a hand in shaping the outcome. The drawbacks are that if there's an inability to communicate between the parties, so that hostilities are so high you can't even have a discussion, or if there's power imbalances or like a lot of hostility and you need a third party to come in and intervene, negotiation is not going to work. So I can't tell you that in 100% of all disputes, negotiation is the way to go, because it's not the case. There are some disputes that require a third party to intervene either through the courts or an arbitration or mediation. The other drawback is there's no guaranteed outcome. So parties can try to negotiate, but at the end of the day, they could both walk away without any resolution to the dispute in question. Mediation, the advantages there are that the third party should be neutral and confidential. So typically we see a third party come in and at the outset, they'll say, anything you communicate to me, I'm going to hold in confidence and not let the other party know the information you're giving to me unless you tell me I can tell them. And so they're really there to facilitate, but they're not taking information from one party and giving it to the other to the disadvantage of the party who gave them that information. So that's typically how a mediation works. They can be time efficient, and they can assist parties in reaching a solution that accommodates everybody's needs and desires. From a drawback perspective, again, no guaranteed outcome and no binding decision. The parties have to, at the end of the mediation, actually put down in writing and sign and agree to whatever they've resolved in the mediation. And at the end of the day, some cooperation is needed, and including who's going to mediate. That's often the big question, is the parties have to agree on a mediator in the first place. So if things are so hostile, they won't even agree on that, you're not going to get very far. Arbitration is basically the closest alternative to a court system. The advantages are that it's private. Court process is not. It's very public. Information exchanged during the arbitration is confidential. Can be efficient. There's relaxed rules of evidence. So our judges and our courts are bound by certain rules of what is or is not admissible in evidence. In an arbitration, you aren't necessarily bound by those same rules. And you can pick a decision maker that has experience in your industry or with not-for-profits in resolving disputes, whereas a judge may not have that same level of experience. And at the end of the day, you can't shop for your judge. You're assigned a judge to your case, and that's who you get. There's no way to pick a judge. The drawbacks are there's no control over the outcome of the decision. So whatever the arbitrator orders is what's binding on the parties, and it's very difficult to appeal that decision to a court of law, and it can be costly. And in PEI, it can be hard to find an arbitrator as well. Typically, there are a few people who do it, but it can be difficult to find an arbitrator in the first place. So your choices may be limited. Court is the absolute last resort, as I've said. And it's really where there's been a total breakdown in the relationship between the parties to the dispute, such that there's no trust, or there's totally high imbalance of power, in which case a court system would probably be the recommended course of action. And you can see here sort of the advantages and drawbacks, but a big drawback is, unlike an arbitration, you really can't dictate the timelines. It's very uncertain time, and because courts are so busy, it's difficult to get court time to resolve a dispute for a not-for-profit organization.
I believe Ains has a question.
Is there lack of arbitrators on PEI? Is it bigger expense to engage someone from off island? So the expense is often the number of days that an arbitrator is going to need to resolve and hear all the evidence. So the amount of cost, it really depends on the issues in dispute and how much evidence needs to be tendered. Is there, in terms of a lack of arbitrators on PEI, I don't see a lot of arbitrations done. I mean, I think it would be very rare that an organization would get to the point where they needed to arbitrate. There's some labor arbitrations that have to happen, but generally speaking, in the not-for-profit sector, typically disputes are resolved by negotiation. There's not a lot of arbitrators on PEI that I know of that would have a lot of experience doing arbitrations in a not-for-profit context. But that said, a lot of their skill set, they wouldn't need necessarily experience with not-for-profits in particular. A lot of the issues that would come up in a not-for-profit organization are sometimes internal, and sometimes the law would just, there'd be rules in the acts that say, you know, the result is X or Y. So it's hard to answer that question, but engage somebody from off island, you'd have to pay for the cost of them coming over and staying here if it's a multi-day arbitration. But generally speaking, I mean, the cost of travel, that's not what's going to drive up your your cost. It's really going to be the time spent to the arbitrator, whether they come from off island or not. Brenda, you've asked, can a lawyer be used instead to arbitrate? I don't know of a lot of lawyers who arbitrate, and it's difficult because of our professional obligations. Typically we're on for, or we incorporated the organization that's having a dispute. So in that case, there'd be a conflict, and a lot of lawyers would have a conflict and couldn't be able to act as an arbitrator if they've acted for one of the parties before. And again, in PEI, it's a small community. So what you want to find and what the parties would want to find and that would only agree to an arbitration is if they could find somebody who's totally neutral and independent. And so it's difficult, especially in the legal community, for a lawyer to act as an arbitrator simply because our professional obligations may not allow it. In terms of dispute resolution strategies and processes, in any dispute, planning is going to be your most important activity in the resolution process. And I think it would help if we came up with an example. So in my past life in Ontario, we had a situation with a hockey association where the hockey association basically took in member fees and rented out ice time so that kids could play hockey. And one of the parents came forward with a dispute that the organization was unfairly granting more ice time to a family member of a director of the board. So in that case, it's an external party coming forward with a dispute to the organization. And so we had to go and take a look at, okay, what do their bylaws say about ice time? What do their policies say about ice time? You know, is there a conflict here because it's the board member's family member that is allegedly getting more ice time? You know, we had to sort of take a step back and try to see and plan what is our communication going to be back to this disgruntled parent? Are we offside any of our obligations as an association? And all of that took time and planning, but we ultimately resolved the dispute with the parent by simply pointing to, well, here are the bylaws, here are the policies, and in all cases of ice time being awarded to either the disgruntled parent's child or the board member's child, they were exactly in accordance with the policies. And so if there's any issue that the parent has, we encourage them, you know, become a member and vote yourself onto the board and make changes to the policies if you don't like the policies. But all we're really doing is following our policies. They've been approved. Everybody else seems to be happy with them. So we thank you for your complaint, but that's how we resolved it and the issue went away. But if we hadn't planned and taken a look at, okay, what are we required to do? What are we doing? And then how do we communicate that to resolve this dispute before it goes any further? All of that took time and planning. So planning is always going to be an important activity in any dispute resolution. Staying calm is also going to be hugely critical in resolution of any dispute. And when I say stay calm, I mean when the issue first arises, don't necessarily become defensive and leap to conclusions. Sit back, analyze, plan, talk to your legal counsel if you need to about how you respond to an issue before it becomes a dispute. And during negotiations or during any litigation or during any mediation, take a breather. Walk out of the room and say, you know what, I just have to excuse myself for a couple of minutes. I'll be back. Walk out of the room, take 10 deep breaths, then make a decision or take an action. Because if your mind is clouded, disputes can get escalated very quickly. And the name of the game is to try to de-escalate and make reasonable, rational, advantageous decisions when you're resolving a dispute. And lastly, just strategize. Like, there are so many ins and outs and avenues and how you package your argument and how you convey your position. All of that matters. So get a strategy in place and talk to your advisors before you hit go. So let's talk about the main one, negotiation. When you're starting out in a negotiation because an issue has arisen, always think about, well, what's my alternative if this negotiation fails? Where am I going to be if I cannot get to a negotiated settlement with my counterparty? That should be in the background of everybody's mind around the negotiating table. If this fails, what am I left with? And that can drive really good behavior. Because if you know that your best alternative is a very expensive court battle that your organization as a not-for-profit can't afford, then you're going to make probably different decisions than if you ignored that fact walking into those negotiations. And you're going to be able to compromise or communicate options for compromise in a way that'll allow the parties to come together and come up with a resolution that they can both live with. They might not both be happy about that resolution, but at least they can both live with it, because the alternative could be really, really bad. So we call it in negotiations theory BATNA, or your best alternative to a negotiated agreement. It's really just what happens if the negotiation fails, where does that leave me? And what's the best alternative there? And if the best alternative is a bad alternative, then you better make sure that the negotiations don't fail. Some negotiation strategies. So the number one, I always tell people, diffuse, de-escalate the situation. And that's often means just not saying anything at all. Listen to the counterparty without taking a position, without judgment, without being defensive or accusing them of anything or counter claiming anything. Simply listening to parties often will resolve disputes because that party just wants to be heard. Another strategy is just avoidance. This party's come forward with a grievance. You've looked at the grievance. It's meritless. It's silly. It has no basis in law. I would say sometimes engaging with somebody who's taking a very unreasonable position or has absolutely no legal basis for the position they're taking is simply avoid it, ignore it. Telling them something or putting something in an email may actually make the situation worse, because now they have something in writing that they could then use against the organization. So sometimes silence, avoid, politeness. They call, did you receive my email where I have this dispute? Yes, we received it. We will get back to you if we think that it mandates a response. Thank you for expressing your concerns. Sometimes kill them with kindness and it'll go away. A third strategy is just competitive negotiation. And that's where you've determined that basically the pie is only fixed. It's only this round and you want as much of it as possible when you're negotiating with a counterparty. So it's a win-lose bargaining. The pie can't get any bigger. It's a fixed amount and it's only going to get smaller. So you're trying to get as much of that pie as you possibly can. Collaboration is a little bit different. That's where you've realized that, for example, there's an ongoing relationship. Your organization needs to make this disgruntled person happy so that it can flourish because it's an ongoing relationship. Well, think of collaboration. The pie's rate is this big. We want to make it bigger, and then we'll slice that pie and decide who gets what. But we can, in the meantime, make it bigger before we go back to that competitive bargaining where we try to divide that pie. In my hockey association analogy, say there was a dispute with a rink, and they said, we're cutting you off if you don't do X or Y or Z or increase prices or what have you. Okay. If there's no other rinks available in town, we really need that rink to get on side with what we want to do. So in that case, I wouldn't recommend a distributive or competitive negotiation, because they have the legal right to just shut us out and stop giving us ice time. Rather, you would go in and try to see, okay, how can we collaborate? Okay, you want more money? Well, we'll give you more money, but what can we also get in return? You know, can we get more ice time with that money? And, you know, there's ways to grow the pie before, again, you slice it. Accommodative bargaining is simply, what do you want? And okay, can I give that to you to make you happy? And then number 6 is simply a combination of you could start out with a avoidance negotiation. You just avoid, but eventually it comes to head and you have to deal with it. Okay, now we're collaborating. Okay, let's see what I can, or we're accommodating. Oh, and then at the end, we've accommodated and we've given them all, the pie's this big, we want to take it all. So it's a negotiation can actually use a combination of these strategies, and depending on what's going on and what the fact situation is, a combination of the above can also work to your advantage. So I do have slides on sort of what each of those steps look like, but in the interest of time, I'm going to just breeze through some of those. And again, the slides will be made available to you, so you can sort of take a look at what some of the activities in each of those types of strategies would look like. But at the end of the day, there's a lot of nuances when you're negotiating, and a lot of strategies that can be employed. And again, I would advise you to lean on your legal and professional advisors if a dispute really has a lot of money attached to it, or a big potential outcome for your organization. You want to make sure that you got the right players in your corner when you're entering in a negotiation like that. There is an arbitration act in PEI. It would outline some of the processes and rules in an arbitration. So there is some law that is embedded in any kind of arbitration in the province. So keep that in mind. But again, if you're going into an arbitration process, you would typically have a legal advisor for the organization who can guide you through those hoops, because they can be quite complicated. I spoke of mediation arbitration. It's a hybrid. I don't know of anybody who does it, just because it can be very tricky with doing mediation and then arbitration. But I do know that those things do exist, and it does guarantee an outcome to the parties if they can't come to their own resolution themselves in a mediation. Keep in mind that a mediation or arbitration, sometimes you're required to do that if a negotiation fails. So a bylaw or a letters patent, very rarely, but could dictate that if there is either an internal, usually internal strife inside of an organization, so directors are feuding with members, or members are feuding with directors, or internally with each other, sometimes there is mandated mediation or arbitration before any party can run to court and try to get a judge to give an outcome. But again, it takes some planning to take a look at what your bylaws and constating documents say. Sometimes it can be mandatory. In terms of the court process, there's an application process under the Companies Act to go to court if a dispute gets there. Sometimes court's unavoidable. Things like slip and fall or injuries, a lot of the time those won't be negotiated beforehand. You'll simply get a statement of claim in the mail, or somebody will deliver it to you on the organization's doorstep that somebody suffered damages and they're looking to the courts to be compensated for them. At the end of the day, though, the process as it's designed now in a court system is that there's encouragement for the parties to negotiate after that process is initiated. So even if you are hit with a statement of claim, it doesn't mean that negotiation isn't possible. Settlements happen most of the time. We always hear statistics in law, but 94% of claims that are initiated in court are ultimately settled or abandoned. So very, very, very few make it all the way through to an actual court trial. So parties negotiate all the time.
Sorry, Andrew, Vicky has a question.
Vicky, you're asking if there are many people working in mediation here. So it's funny because I know I've heard that there is a firm, Michael Fleshman is a lawyer in town, and I believe he is opening a small firm here with a former judge, and I don't know if that judge is doing mediation. I know that they're planning on doing some arbitration work. But judges have the skills of mediators and arbitrators. They are really there a lot of the time, especially pre-trial, to get people to a negotiated or settled outcome rather than using court resources and time. So I wouldn't be surprised if that judge is looking to do mediations, but why don't you, Vicky, send an email to Christine, and I can ask around here for the names of any potential mediators in the province in case you need one. Under a court application, again, very low barrier to entry to file and then serve a statement of claim. Once a statement of claim is issued against an organization, you can't sit on it. You have to file a statement of defense, or you would be noted in default, and the allegations alleged against the organization deemed to be true and admitted. So it's very important, if you are served with a statement of claim, to find a lawyer and understand what you need to do in order to make sure that your organization is protected if you are hit with a statement of claim or an application. Time matters because there's sometimes very short time periods by which you have to reply to any step in a litigation process. And again, this is the design of the system, is to force people along to a resolution. And without very tight timelines, people could sit on their rights or obligations. So the law steps in to force people along through the process. In terms of possible orders that could be made against not-for-profit corporation, the Companies Act, again, more modern statutes have a list of potential remedies for members that are aggrieved or directors that are aggrieved or what have you. The Companies Act doesn't provide a list of remedies. And so basically, it's up to a judge to come up with what remedies they think works best for a specific case. And they would basically be empowered to order a lot of the same remedies that are listed in the other statutes, which I'll get to in a second. But the big one is they could order costs against a party for either all of the litigation or any step in the process. So just keep in mind that not only may your organization be hit with the cost of its hiring its own lawyers, but it could have to pay for the other parties too if it acts unreasonably or the court determines that it's not successful in defending itself. So again, if you are hit with a statement of claim, it's imperative to seek legal counsel and deal with it sooner rather than later. Under the Canada Not-for-Profit Act, if you're governed by that act, there's a more formal process for both bringing a claim against the organization if you're an aggrieved member or director, as well as defending that. The orders that can be made are listed. So it actually enumerates what kind of orders that a judge can make. And you see them here, but this is not all of the list. There's a lot of orders that a judge could make against an aggrieved person. So these would be for things like breaching your bylaws or your articles, or the directors have taken steps to really prejudice somebody. There's restraints can be ordered. The judge could order your articles or bylaws to be amended. They could appoint directors in the place of the current directors. They could ask a corporation to pay a member, all or part of their membership fees or any other amounts that they've paid to the organization. There's all kinds of things that they can do to rectify a situation they view as being unfair to an aggrieved person. And with that, I know I went a little longer than I had hoped to, but I'm happy to take any questions that anybody has. And I open it to the floor.
Hi, there's a question coming in, sorry.
Yeah, so Vicky, I'll answer your question then. Bridget, I'll send it over to you. So Vicky's asking just a comment. I've been involved as a volunteer on councils for regulatory bodies such as a public representative and have served on a couple of investigation committees as a public representative. Having a list of mediators would be helpful to these nonprofits as full-blown investigations are costly and sometimes overkill. Yeah, so investigations. So sometimes sometimes those might be needed before a mediation, Vicky, just because it's fact gathering, right? So I don't know, maybe you're talking about a specific instance, but for not-for-profits, sometimes an investigation is warranted before people negotiate or mediate or arbitrate, just because there could be something that's gone on that
Yeah, it's
third party.
sort of in the cases I've been involved with, there has to be some investigation, but a full-blown investigation is like especially with some of the new regulatory bodies that have started up under the Regulated Health Professions Act, for example.
Yeah.
They are like it's new territory for many of them, and instead of having to go in heavy, there are opportunities for mediation sometimes between complainants and the professionals involved that could resolve a lot of things. But without a list of professional mediators or knowing what do you expect of a mediator, even it's hard to know how to move that forward, which is a lot less painful for people involved and a lot less costly. It's good to hear there's somebody who might be interested in doing more work in the area.
Yeah, exactly. And no, I know in the context of investigations as well, like at law, you're innocent until you're proven guilty, but even the fact there is an investigation could be really damaging to somebody, even if the basis for the investigation it turns out to be meritless. Even the fact that there was an investigation sort of paints a picture in people's minds, right? So
I have a question. I'm going to ask it in real life. Is that okay?
absolutely, Brenda.
All right. So I guess as a comment and a question. So I work within not-for-profits. Like most of my time is used within two not-for-profits, 3 that I'm on the board or I'm involved with.
Yeah.
But I'm also a not-for-profit consultant out of Ottawa, but we do international work. And just being in PI and having a few people consult with me and being involved a little bit with a few not-for-profits, some folks wanting to start up, and after looking at the bylaws, although there's some things in there, you can just take the cookie cut bylaws and submit any different things that you need to tweak for yourself, as long as they're meeting laws. So I suggest to people, well, first see if there's a not-for-profit that does what's on your heart.
You do.
That's
Yeah,
always the best thing.
exactly. Yeah.
And not try to copy what's already going, just be involved in it, because that's what, at the end of the day, not-for-profits are all about, right? Purpose, and being a sole proprietor of a not-for-profit because you have a good idea is not a good idea, in my opinion. And PI is just so happening, and this community sector network PI is so innovative, and it just surprises me to see how far behind, like that the act has not been modified for a long time. I'm just wondering, is there some lobbying or something that could occur? And I know community sector network plays that kind of role to move the government forward so that people can incorporate, you're only doing work on the island, you don't need to be incorporated, but I suggest if it's really something you need and want to do and it doesn't exist already on the island, go federal, even though you'll never do work out of the province, just because they have it together. And that's in 2014, they changed the law so that people couldn't break the law. But
Right.
PEI is so far behind with that. So I'm just wondering, as a lawyer, is there a way that groups could lobby to have the government improve the Not-for-Profit Act?
Certainly, I don't, and maybe Christine knows if there's any lobbying efforts going on, but it was the same case in Ontario. So we had in Ontario a Corporations Act, and it was a mess because it was started and first drafted in like probably the 1800s. And it was patchwork. I mean, you had for-profit companies in there for a while, and then they in the 80s came up with the Business Corporations Act. And then they brought insurance companies into this act. So there's a whole part about insurance companies that only apply to insurance companies. And then there was everything else that applied to it was a Frankenstein act. And they finally got around to implementing the Ontario Not-for-Profit Corporations Act in 2021. And they passed the statute in, I think, the early 2010s. And it took the legislature 10 years, it might have been 11 years, to make all the consequential amendments that had to be made to the other acts out there that refer back to the Corporations Act. So I'd love to say that it's an easy fix, but some of the issues are that the Companies Act, like the Ontario equivalent, has been around for so long that it actually is going to take a lot of skill and attention and time in government to make the necessary amendments and to even draft the legislation in the first place for the Not-for-Profits Act. And I hear you, I'm not a fan of reinventing the wheel. Go and borrow from another province who's gone through this before, or borrow from the federal equivalent.
Federal.
Don't draft it from scratch. But this issue, I can tell you, is from the government's perspective, it's not going to win any votes, and it's not the issue of the day. And they have so many other things on their plate that I think it's going to be a tough sell to advocate for the changes in the Companies Act. And if they are open to doing it, I can tell you it's going to take a long time. So I agree with you. If I have new incorporations that are not for profit, I tell them, like, we should really do the federal one. Because it's got that backbone, that modern backbone, and a bylaw builder and all kinds of things to save time and money. Because it's not for profit. Like, we're not out making money, we're out doing good for the community. So don't spend it on legal fees and government filing fees. Spend that money on doing good for the community. And you know, there's a lot of it's complicated, but
I know. But I would argue that if we could show metrics on the impact that all the not-for-profits are having on the target groups they work with,
yeah,
and they can imagine that not-for-profits don't have the proper outline of governance based on what the real law should be, then they can't perform as accurately or even include more people, because it seems very, from some of the boards that I've seen, although I've seen other boards super high functioning, that they have no clue. Like, they're pulling bylaws out of, you know, where, and they don't look to see if they match up. It's just based on what they think is best for themselves within the organization. Anyways, I could go on, but I'm sure Community Sector Network will be on something one day soon.
You're preaching to the converted, I think, Brenda.
Go ahead, Christine. I think Christine already has something.
On to Alexia for sure. I believe Vicky has a comment.
Sure. Thank you for bringing that up, Brenda. When COVID happened, I do a lot of work with not-for-profit organizations as a consultant as well. And when COVID happened, a lot of them got into trouble because their bylaws said they had to meet together.
Yeah.
And at the time, Ontario took a move that was great. It publicly made a change, or allowed for a change to happen to their Not-for-Profit Act
Yeah, I
that
remember,
allow
yeah.
organizations to override their own bylaws during that time period. I'd made suggestion to our provincial government at the time because I was dealing with a number of not-for-profits, and I said, why are they all wasting their time like getting me involved when all it would take would be government to say, listen, don't worry about your bylaws for now, we'll get this sorted, but in the meantime, this
Yeah.
requirement of your bylaws can be waived. And anyway, got no response. It was very frustrating. And I've helped organizations become write their bylaws and become incorporated under the PEI Companies Act. I've worked with some organizations that were federally incorporated. And to be honest, for small not-for-profits, meeting the requirements of the federal act are kind of onerous. And it might again be too much for them to handle. The provincial act is garbage because it's really they pulled the businesses out of that act years ago and just left not-for-profits in this lame duck act that part 2, which are the rules for nonprofits, keeps referring to sections of part 1 that they no longer even hold businesses accountable for because they've created a whole new act. So there should be an act for PEI. There really should be for the not-for-profits. But the federal act, there are some challenges with meeting its requirements, and even to get established, it's so confusing. But you can be incorporated easily under the PEI Act. But if you go for best practices, by following some of the requirements under the federal act, you can't go wrong, because it's just good practice in a lot of cases, but sometimes way more than what's required for an organization who's never going to work outside the boundaries of PEI.
Yeah, no, I hear you. Some people, it's psychological. They're a PEI association, so they want to be a PEI act, the PEI company, and that's fine. But I agree. The act is a bit of a Frankenstein right now, with that part 2 and part 1 being taken out. Yeah, I hear you. Bridget, I think you had a question earlier, and I'm sorry if I failed to come back to you.
No, that's okay. My question was really just because I'm embarking right now on getting a certificate in case management with UPEI, and the tuition fees are $2,500. I'm hoping to take that and then use it towards becoming a legal navigator. And so the position is technically mine right now for the taking if I want to. I just feel like I need to have a little bit more understanding of the legal landscape. And so I was just curious, if I do have this course and I pay for it, can I then, because I currently work with the government, be able to have some kind of funding that's able to pay this back? I did read somewhere there was up to $2,500 that would be reimbursed if the schooling that I take is in line with the work that I'm doing. And I was just curious if you remember the name of this grant or this pool of money that is available to pull from.
No, not off the top of my head, Bridget. I don't know if anyone else on the.
It might be on income tax, you can claim it.
No, it was in the it was some workers union. It was on their site, and it basically said that if you work for the government, which I currently am with the early development sector, that's why I was looking into it. I was just curious if you knew the name of that, because it escaped me.
No, I'm sorry, I don't.
No, that's okay.
No.
Thank you, though.
Are there any more questions for Andrew?
I do have
I
a
have
question.
so many, but I can't do it.
Hi,
I
Aaron.
do have a question. Yeah. I hope folks can hear me okay. I'm just in my car, of course, hands-free.
Yeah.
But I'm just wondering if I'm hearing a lot of folks talk about sort of the protections in place for organizations at this current moment in time, the protections that are in place while being incorporated under Corporations Canada, rather than, the Prince Edward Island companies. And so if I'm with an organization that is currently incorporated with PEI rather than federally, you know, and we have bylaws in place, of course, is there sort of a recommendation? I mean, of course, you can't give advice, but would you say that it might be a better practice to shift to registering and incorporating federally, if you're already incorporated provincially, or would you say it's better to sort of just stick it out for now and hope that more regulation comes in place for the province?
Yeah, Aaron, so I would say there's a couple things. So if your organization is looking to do something or implement something that's legal under the federal act, but not legal under the PEI Act, then that might be a basis and a good excuse to continue to the federal act. But otherwise, a lot, and I would expect most issues that the organization wants to pin down and address can be reduced to writing in a bylaw, regardless of which act that you're under. And the bylaws can you know, address a lot of those things and even implement some sections that, for example, can't be amended without the unanimous consent of all members, for example, to make it very difficult, or 2/3 of the members rather than just the majority rule, which is typically the default under most people's bylaws. So there's ways to draft and pin down issues if you need to in the bylaws rather than continuing. And the only thing I can think of is if there's something that you're trying to do that's illegal under the PEI Act that is not illegal under the federal act would be the only basis, I think, for continuing. But I can't think of any other examples, and there could be some, but it really just depends on what issue you're trying to address and whether it's legal under the provincial act and not under the federal act.
That's great. Thanks so much for your help.
So can I just clarify your role in working with not-for-profits then?
What's that?
Is that okay?
Oh, whoa.
And talking on, I'm on the computer, sorry. Sorry, somebody's just here with me.
My role?
Yeah, so are you focused on working with not-for-profits on the island? Because I'm just,
Yeah, so we act for a lot of the not-for-profits on the island, either amending, updating their bylaws and governance documents, or when other issues arise, as many legal issues do inside any organization, regardless of whether you're generating profit or not. Things like employment issues or litigation issues, or looking at acquiring property issues or disposing of property issues. Certainly, we're sort of a one-stop shop because we've got everybody who can do those things under the same roof. It won't necessarily be me litigating for you, but certainly if disputes arise internally with respect to the organization's governance, I'm certainly somebody who can be called upon to help assist in dealing with those issues as they arise.
thank you.
And more often than not, Brenda, I'm involved in sort of just the drafting of what could happen and how do we create a governance background that's going to deal with it in the quickest, most efficient and cost-efficient way.
And I guess I'll ask you one more question. So have you ever had a situation where the members actually have a grievance with their board and there's a whole funk that goes on?
Yep.
Yeah.
Both for-profit, I mean, they're called shareholders rather than members, but
Right.
I'm often involved in shareholder disputes, but the same issues skill set applies to members as well. Somebody's not happy with how they're being treated, and I'm typically on for the organization. So it's important to note, like, as a lawyer, if I'm on for the organization, I'm not on for any one director. I'm not on for any one member. My duty is to the organization to make sure that its best interests are looked after. And if if I'm on for an organization and a director or a particular member or shareholder wants to get a lawyer and fight about something, I can't act. I would say, you have to go find somebody else to act, because I'm on for the organization as a whole. I'm not, my loyalty isn't to one shareholder or member or director. I'm on for the organization as a whole. And sometimes the organization needs that. They need that oversight. But it really depends on the circumstances and what the issue is and who's fighting who.
Andrew, I just wanted to say thank you for taking the time today and running us through all this terminology. And yeah, I do have to leave the session, but I just wanted to make sure that I said thank you beforehand.
I appreciate it, Bridget, and thank you for your question and for attending.
Thank you. Bye.
Bye, Bridget.
See you,
So-
Brenda.
I worked with Bridget this year. She's very cool. We hired her with our not-for-profit for the summer.
So we'll probably start to clue up if there are no further questions. I'd like to thank everyone for joining us today. And I know some of you have joined us for multiple sessions, so we really appreciate it. The legal series has been a wild success, and we're really, really happy about that. And I think it's very important information for all nonprofits to have. We've covered a number of topics over the 4 sessions. Thank you, Andrew, for your knowledge and today. And this video will be available. I'll send out the link, and Andrew is going to send me along that slide deck as well, and I'll share that as well. Final word to you, Andrew.
No, I appreciate it, and thank you, everyone. And I look forward to seeing you around PEI.
Awesome. Thank you.